to Gettin Legal with It, a podcast for Colorado young lawyers by Colorado young lawyers. I'm your host, Kevin Chaney. For those listening to us for the first time, I'm a personal injury and criminal defense lawyer here in Colorado. I graduated from the University of Colorado Law School in 2014 and founded my practice, Chaney, Galuzzi & Howard, LLC, a short time later. I'm a member of the Colorado Trial Lawyers Association, where I'm the co-chair of its New Lawyers Division and also serve on the executive and legislative committees. I'm also a member of the Colorado Criminal Defense Bar Association and the Colorado Bar Association. For the Colorado Bar Association, I serve on its Board of Governors, the CBA Young Lawyers Division Executive Council, and finally, I was just appointed to begin serving on the CBA's Executive Council. If you're interested in learning more about any of these wonderful organizations, please feel free to shoot me an email at kevin@cghlawfirm.com. This podcast is created and sponsored by the Colorado Bar Association's Young Lawyers Division. Our goal with this podcast is to bring you bi-weekly episodes with information that is both fun and informative for young lawyers. We have some awesome guests lined up, and we're just getting started. If you like our podcast, please leave us a review and tell your colleagues. With that, let's jump right in. I'm super excited for our guest for today's episode, our first judge on the podcast. With me today is the Honorable Kato Crews, who is a magistrate judge with the U.S. District Court for the District of Colorado. He was appointed in August of 2018. He earned his law degree from the University of Arizona before joining the U.S. National Labor Relations Board. He then entered private practice as an associate at a large Denver firm, where he worked his way up to partner before leaving and founding his own small firm in the Denver Tech Center. When practicing law, Judge Crews was a trial lawyer who focused on traditional labor law and employment law matters and general civil litigation. And so with that, we'll jump right in. Judge Crews, so happy to have you here today. Thank you for coming on the podcast.
Sure, thank you. I'm very happy to be here.
So I know we just covered a little bit of that general biographical information, but let's learn a little bit more about you. Why don't you tell the listeners a little bit about where you're from?
All right. I'm a Colorado native. I grew up in Pueblo, Colorado, was born in Pueblo, Colorado. My dad lived in Rye, Colorado, which is a small town about 20 miles south of Pueblo. Mm-hmm. And so when I finished middle school, I moved to Rye to live with my dad. So I went to a Rye high school. I think at the time they had 164 students maybe. And I was the only African-American male in my high school. But it was a very good experience. So Colorado native, grew up in southern Colorado, did my undergrad in Greeley at the University of Northern Colorado. I thought I was ready to experience something new for law school, so chose to go out of state. I was actually trying to escape Colorado winters. My family and I were not winter sports people, so went to Tucson, Arizona for law school and ended up missing Colorado a great deal. I missed the four seasons, actually missed the snow. And so was anxious to get back to Colorado after law school.
I can relate to that. I was born and raised in Casper, Wyoming.
Okay.
And when I went to my guidance counselor, I was like, one requirement is I better never see a snowflake wherever I go. And ended up going to the University of Hawaii. And then realized that as awesome of an experience as that was, that I missed the seasons and I just missed the Rocky Mountains. And it brought me back. Before we move on, being from Pueblo and then doing labor law, if I remember correctly from my labor law class, and Professor White, if you're listening, I'm sorry I don't remember this off the top of my head, but Pueblo actually has a pretty robust labor history, right?
Uh-huh.
Is there no?
It really does, and with the CFI steel mill that is there, but was active back then, it has a pretty rich history with respect to organized labor.
Oh, that's very cool. Very cool. And what made you kind of want to be a lawyer? What drew you to the profession?
Yeah, when superficial reasons, really. My dad was a solo practitioner in Pueblo. He never really talked to me about what he did as a lawyer, so I didn't quite understand it. But I knew that he looked really good in his suits, and I thought, I'd like to do that. I also knew, though, that he was helping people. I vaguely understood that. And so I decided then that I wanted to be a lawyer. At least I wanted to go to law school. as I got older, I learned a little bit more about what lawyers do. I actually had decided I was going to go to law school regardless for the degree, but I originally was wanted to go into public relations, and I wanted to work for a PR firm and help companies manage their PR crises. But when I was in law school and you're learning everything you learned there, and I began to realize, well, that's what lawyers do, is they help clients and companies manage crisis. And so I thought, well, I might as well use my law degree for what it's intended for. And so it was probably after my first year of law school, I decided I would actually use my law degree to become an attorney.
And at that stage, kind of in between that 1L and 2L year, is that when you kind of decided, hey, labor kind of might be an interesting practice area? Was that an interest prior to law school, or was that something that developed later?
Yeah, so with my degree in undergrad was journalism with an emphasis in public relations. The summer between my first year and second year, I did an internship with Sears Roebuck Company in their PR department. Mm-hmm. And I can't remember now, I had taken a labor employment law class. That was my first semester of my second year. But I began to see a relationship between employment law and labor law and public relations in terms of companies managing their workforce and their different target audiences that companies have to deal with effectively, and it felt something similar. It seemed similar to some of the public relations things that I studied in undergrad, and so I was drawn to labor and employment law in law school, and felt that, well, now that I've decided I will actually use my law degree to be an attorney, that maybe that would be the place for me, is to see if I could pursue labor and employment law.
And what brought you to the National Labor Relations Board versus maybe, jumping into a firm or working for a union? What kind of attracted you to kind of the governmental side of the labor question?
So to be quite honest, that was a bit by accident as well. I feel like kind of my start in becoming a lawyer and even choosing to go to law school, it was not as calculated as you might think, or as it is for others. But I had missed the boat on on-campus interviews at University of Arizona, and quite frankly, again, a moment of naivete. I didn't really understand that was taking place. I didn't know those were opportunities for us. And I didn't know much, coming back to Colorado, I didn't know much about the legal landscape here. I didn't know anything about the law firms and their cultures, their reputations, et cetera. And so I was scrambling a bit, trying to figure out how am I going to get back to Colorado and have a job. But came across an announcement for a position as an attorney with the National Labor Relations Board, which was a bit of divine intervention, perhaps, since I had that interest in labor law. So I applied, and it worked out.
And it's interesting. We've had several guests on the podcast, and that actually is sort of a recurring theme in talking to people, that the vast majority of them did not end up at the place they thought they would kind of when they started, law school. And there's a lot of, I accidentally, met this guy for lunch and we had a connection, and then he offered me an internship, and next thing I know, I had switched my whole career path, or, I took this class and was inspired by a professor and decided to go that route, or, and I think that's important for a lot of our listeners who are young lawyers and law students, is it's okay to not know. Like, it's okay to not have a master plan, or even if you do, it's okay to be flexible with that plan, because if you're open to the opportunity, it'll work its way out generally.
Right. And I think that flexibility is absolutely key. People will find, or should find, over the course of their careers, different doors will open, different connections will be made. I mean, you don't really know and can't anticipate what's going to come up. But if you have that flexibility to adapt and recognize those opportunities and take advantage of them when they come, you can make great strides with your development and your career.
And what was it like working for the NLRD? I know a little bit about it, but for our listeners who may not really understand what the NLRB even is, what does it kind of do, and kind of what was your role there?
So it's the National Labor Relations Board. It's a federal agency. They enforce the National Labor Relations Act, so a federal law that essentially governs the relationship between unionized companies, so companies and their unions. It also has certain provisions that govern non-unionized workplaces. In terms of employees have certain they're called Section 7 rights. So the right to come together for concerted activity, essentially to better your working conditions. Even though you don't have a union, the law allows employees to come together to do that. And so the NLRB enforces that act, which means we dealt a lot with unions filing charges or grievances, if you will, but charges really against employers, saying this employer is violating the National Labor Relations Act by coercing employees, in their labor law rights. Or employers, didn't happen often, but they would file charges against unions. We would investigate those charges, determine if there's any merit to those charges. We would write recommendations to the regional director of the NLRB on we should issue a complaint or we shouldn't. If we issued a complaint, then we became a prosecutorial body. And so it's all administrative stuff. So it's administrative hearings, trying to prosecute for whatever the allegation was in the grievance. And then lastly, they also handle union organizing elections. So which is the heart really of labor law. So employees who decide they want union representation would file an election petition with the NLRB, and the NLRB would conduct an election with a box and ballots and count the ballots and so forth, and certify the union as the bargaining representative for a group of employees if the vote came out that way.
Interesting. And so what kind of caused you to transition? Because then I know after that you ended up going to a large kind of Denver firm, right?
Right. So the NLRB was a great place to start, but it was a governmental agency that enforced one statute. And so I began to feel like, we would handle the charges all in the same fashion. And then just it all seemed to be a little too routine, and I felt like there's just more I want to do with my law degree than I'm able to do at the NLRB. And so after I was there for a year, after a year I had decided that I wanted to dip my toe in and get into a law firm. And by then I still didn't. I knew a little bit more about the legal landscape here in terms of law firms because we dealt with some of the law firms there. And I at least knew the players in town that had labor and employment law practices, so I had a little better knowledge available to me to try to enter private practice.
And, I think this is something that young lawyers struggle with, on a kind of routine basis, is knowing when to kind of make a change or to kind of, switch, not necessarily their practice area, but switch from kind of one type of employment to another. Is that something that I guess you would recommend, that, it's okay for young lawyers to kind of, get some experience over here and then kind of do something kind of completely different? Do you think that's beneficial to their careers, or should they kind of try to stay focused and work their way up, whatever, kind of situation they're in?
I think that the young lawyers need to find what is going to make them happy and what's going to bring them balance in the practice of law, and where are they going to be most satisfied. So, I wouldn't suggest making a change just for the sake of making a change. For me, it was, I'm bored here. I feel like there's so much more I can be doing in my community and as a lawyer, and I need to find a way to do it different. But I think be purposeful about it, have particular reasons why you would want to make a change. But by all means, don't fear making changes, because I think in making those changes, you give yourself the greatest opportunity to, again, make strides in your development and strides in your career.
When you went into that firm, did you stay primarily focused on kind of labor issues, or did your practice area focus kind of expand a little bit? Obviously, what you were doing expanded because now you were, working as an advocate. But did you kind of begin to branch out, or did you really kind of stay with that niche?
It expanded. So when I was hired to be a part of the labor and employment practice group at that firm. So that was largely and primarily what I did, but I also worked with other of the partners in the firm doing commercial litigation. A big part of what I did, which is something I would recommend to young lawyers looking for opportunities, at least young lawyers who practice in the bigger firms. I mean, sometimes these opportunities to get into court and get stand-up time are few and far between. I was able to work with one of the partners. I was his go-to for HOA covenant enforcement cases, which, there's a pro se person, always a pro se homeowner on the other side. It's a lawsuit because their lawn was too brown or the car was parked out in the driveway too long. So not sexy stuff at all. But I got into county court often on bench trials. And so it was a good opportunity to learn how to be a trial lawyer and learn how to present evidence, learn how to talk to a judge. So I did have various opportunities available to me at that firm outside of my efforts to focus on labor and employment law.
And getting into court as a young lawyer can be such a beneficial experience. When we launched our firm, one of the main reasons why we did criminal defense in addition to personal injury work is just the ability to get into court kind of way more often and to really get that experience, because there's not really a way. You can take trial ad classes, you can watch trials, but until you're actually doing it on kind of a low stakes, I mean, obviously every case is important for the individual client, but, something where, no one's going to go to prison for the rest of their life if you lose is such a valuable experience. And I know that a lot of organizations, I was at the ABA's mid-year convention in Austin right before kind of COVID took over, and there was a robust discussion about what more bar associations can do to push, especially the big firms, into allowing young lawyers to present more of the motions or actually kind of do more of the work in an actual trial. And
right.
It's a tough call, because on one hand, you kind of understand the client wanting the most experienced, best person. But on the other hand, like, that person is eventually going to retire. And if your bench isn't ready to kind of pick up the mantle, the legal system might be kind of in a tough place.
Right, exactly. And, our profession, unfortunately, has gotten away from the apprenticeship model of training young lawyers. And I think that's something that is important. And I think that means going to court with young lawyers, but letting them have the full reins and just being there to be supportive. And so I was fortunate over the course of my career at the big firm that they were able to foster my development in that way.
And I know from your bio that you were one of the youngest associates to make partner back in 2008. And I know that as a lot of young lawyers are listening, are thinking about, how am I going to make partner one day? What advice, and I know there's a lot of different things and it depends on the firm and the practice area, but what kind of general advice would you give to a relatively new associate at a big firm who, kind of envisions themselves making partner one day? What kind of things can they be doing to kind of help them on that track?
Sure. So some of the advice I would give is, first and foremost, focus on the fundamentals of practicing law. Like first and foremost, learn how to be an excellent lawyer, whether you're transactional or you're a litigator. Just learn how to master those fundamentals, learn to be an excellent attorney, because all of that's going to show in the work that you're turning into these partners, and they'll be impressed by it. They'll want to give you more work. They'll have more confidence in you as a lawyer. I think that's part of it. Two, I used to talk to young lawyers coming into the firm about their internal and their external marketing. So I think there's some internal marketing that can be useful, which means, as if you're involved in your community, if you're involved in different legal organizations, if you're getting different recognition for some of the things you do, make sure that the people within the firm know that you're getting recognized in different facets, because again, I think that breeds confidence, it impresses partners, et cetera. And then the external marketing, a little bit of the same thing, but that's how you're out there in the community, you're building your brand, you're getting your name out there, which also trickles then kind of back to the firm as they see your name associated with different things in the community. I think those things give partners a view that you are somebody that can get out there, you know how to interact with the community that may translate into being able to generate business and build a book and so forth. So I think, but first and foremost, you got to focus on the fundamentals. Learn how to be a good lawyer. Once you start to get comfortable and start to master that, then think about your branding both internally and externally at the firm.
You know, it's interesting as you were talking about kind of the internal marketing aspect of that and kind of making sure that people know kind of what you're doing and kind of what you're accomplishing. Because I remember being in law school and I, knew a lot of these people over the course of 3 years, and it sometimes would be like 3 years in that I would discover some of this really impressive stuff that some of my classmates have done. I'm like, I've been decent friends with you for 3 years, and I had no idea that you founded a nonprofit and like moved to Chile for 3 years.
Right.
And, and I know it's because a lot of them are just humble people who, are not necessarily used to, bragging, if you will, but there's a line between, kind of bragging about yourself, but also having that confidence to kind of say, like, this is what I've done. This is my experience. And this is why this helps me, do X or do Y. And so I think it's important that you kind of said that, you got to kind of get over that hump of self-promotion and you can do it in a way that's still humble and, not annoying to everybody, but you do need to be able to kind of sell yourself a little bit and be like, I am the man for this role or woman for this role. And kind of here's why. Right.
You have to advocate. It is, of course, it's excellent to be humble, but you have to learn, you can still be humble while advocating for yourself and you can still be humble, but be a shameless self-promoter. An advocate for yourself, and I don't know if it's still this way in some of these big firms, but where I was, in part, that was made easy because we had the internal marketing department, and so I would go to the marketing director and say, "Hey, I got this award," and then they'd put it out in the internal newsletter that would go around at the firm that everybody's reading about what people are doing. And so even the seemingly mundane, quote unquote accomplishments, I would make sure to let the marketing director know. And 9 times out of 10, that made its way into something. And so people would see my name a lot internally, and I think that helped.
I want to kind of shift gears here. We've been talking a little bit about big law, but then you eventually left that firm and founded I assume a much smaller firm in the tech center. What kind of drove you to kind of launch your own firm?
So I, at around that time when I was at the big firm, I got tired of some of the big firm things, the focus on the numbers and billable hour requirements and so forth. And so, I tell people the story. My son was, I don't remember how old he was at the time. Might have been 4 or something. And my wife needed me to stay home with him one day. And when she told me that, my first thought was, well, that's going to cut into my billable hours. And then I was disgusted that, here's my opportunity to, really step up as a father, be there for my son. He's sick. He needs me. And my first thought was about my billable hours. And then my mind scrambles. When am I going to make those billable hours up? And I didn't like that at all. And so I thought, there's got to be a different way to practice law where that's not my mental focus, because I didn't like that was my mental focus. I wanted to be able to be there in the moment, be present with my family, and not be focused on the job or the numbers. And so that was kind of the straw for me. One of my colleagues had left the firm a few months before I did. And so I watched how things worked for her, talked to her on nearly a daily basis. And that gave me some comfort with taking on that risk and leaving the big firm to go join her. And we had 6 attorneys at the time, I think, when we first started.
As a small firm owner myself, I like to tell people that 90% of the time I'm happy with my decision, and about 10% of the time I'm like, man, it would be so much easier if someone else was just signing my checks.
Right.
But, it offers a different type of kind of risk reward situation. You get a lot of benefits of that flexibility of schedule and kind of to practice law the way you gotta practice law. And then you also have that responsibility that instead of, someone signing my checks, now I'm the one responsible for making sure that we have enough revenue. And it does kind of add these different pressures and stressors. But I agree. I mean, for quality of life, you kind of doing your own thing or working for a smaller firm has really, at least in my experience, been really rewarding.
Yeah, and that was my experience as well.
Did you know kind of early on in your career that you were interested in being a judge one day? When did that kind of pop into your head of, hey, that might be something I would like to do?
I didn't know that early on. I had never really thought about it or planned on it, that's for sure. I had flirted from time to time with the thought of maybe Colorado Court of Appeals. I had done some appellate work in my career, and I really enjoyed it a great deal. So had kind of flirted with that idea, but not anything serious. So it wasn't until, maybe November or so of 2017 that I was dissatisfied with my practice. I wanted to do things differently again somehow, and ultimately I wanted to do them differently because I wanted to make a greater impact on the legal system. Mm-hmm. I wasn't sure what that meant exactly or how I would do it. One of my partners and I toyed with what if we got into civil rights litigation or different things. So I was really just thinking about and pondering how can I do this differently that I'm making a greater impact on the system. As I was going through those thoughts, the email announcement came out that this position was open. And so I thought, well, you can't make a greater impact on the legal system than to be a member of the judiciary. So I thought I'd give it a try. And I hadn't contemplated really a trial court. I'm a bit introverted, and so that was why the prior thoughts of, well, maybe Court of Appeals.
Right.
But with my heart really being at the time thinking about, I want to make an impact on the system. Our trial court judges are the ones on the front lines interacting with the public and the people and the lawyers, and so that's where I think. I thought as a trial court judge, as a magistrate judge on the federal court, I could really have an opportunity to make an impact.
Can you tell the listeners a little bit about how, first of all, what a magistrate kind of does in relation to an Article 3 judge? And also, I know that obviously federal judges are generally appointed by the president and confirmed by the Senate, and I think the process is a little bit different for magistrates. So can you tell us a little bit about that process?
Sure. So the Article 3 judges are the district judges. It's Article 3 of the Constitution. They're appointed by the president. They have lifetime tenure. We fall under Article 1, and we are magistrate judges. So what we do is we assist the district judges. We handle the preliminary matters, essentially, in criminal felony cases and in civil cases. We manage the discovery in civil cases. District judges can refer motions to us. If it's a non-dispositive motion, so not a motion to dismiss or not a motion for summary judgment, if those are referred to us, we issue orders. So we make those rulings that are binding on the parties. If a district judge refers a dispositive motion to us, then we issue a report and recommendation. So it's basically in the nature of an order, but we're recommending to the district judge that the motion be denied or the motion be granted in part and denied in part. Then the parties have 14 days to file objections to our recommendation, and then the district judge reviews all of that and either adopts our recommendation, rejects it, adopts it in part, whatever he or she chooses to do. Parties can consent to our jurisdiction in a case, which means if they consent to us, then we're the presiding judge on the case from its inception through to post-trial. And so we get the opportunity to preside over jury trials or have bench trials. And then in criminal matters, we are on criminal duty 2 weeks every 12 weeks. During criminal duty, we take we give advisements, we take plea, or we don't take pleas, we give advisements, we do detention hearings, we do preliminary hearings, we do the preliminary things in a felony case. and then the district judge handles the felony case. In misdemeanor cases, we have a petty docket, and so in those cases, we preside over those from through to sentencing.
And so, Judge Crews, I wanted to talk to you a little bit about the process for becoming a magistrate judge versus the Article III judge. So we know the Article III judge appointed by the president, but what is the process of becoming and who decides how you become a magistrate?
So the process for magistrate judges is similar to the process for state court judges. So there's an application to complete. The chief judge convenes a merit selection panel that consists of 9 people, two non-lawyers and 7 lawyers. So you apply, you submit your materials. The merit selection panel is charged with narrowing it down to the 5 most qualified candidates. If you make that cut, you interview with the merit selection panel. I'm sorry, the merit selection panel selects however many they're going to interview. Mm-hmm. So you interview with the merit selection panel. They narrow it down to 5. Those 5 then go on and interview with all of the district and magistrate judges you're interviewing with them all at the same time. But you interview with all of the judges, and then it's the district judges who vote, and they select you. So I'm hired by the district judges of the federal court. We serve 8-year terms subject to reappointment. So around the time of the end of the 8-year term, another merit selection panel is convened. I don't know exactly what their process is, but they go through a process. They make a recommendation to the district judges as to whether or not the magistrate judge should be retained or not, and it's up to the district judges. So we serve at the pleasure of the district judges.
Are you assigned kind of one district court judge that you work for, or do you work for multiple, and does it rotate? Or tell us a little bit about that setup.
We work for multiple. They talk about the wheel in terms of cases being assigned randomly. We are also on the wheel, so when cases are filed, they could be drawn to us directly, and then the parties have a deadline to either consent to our jurisdiction or not. And then if they don't, then the case is assigned out to a district judge, and then we'll typically stay on that case as the referral magistrate judge to handle all of the types of things that I've described.
What qualities or jobs or other things kind of in your background do you think helped you get picked for what I'm sure was a pretty competitive process? Mm-hmm. I'm assuming there's a lot of people that would love to be a federal magistrate. And so for the people, young lawyers, law students that are listening, what kind of things about you or that you did or that you experienced do you think helped you get picked?
Well, I think, certainly I think it was my work as a trial lawyer, my reputation as a trial lawyer. I think that it maybe was helpful that I had practiced in a big firm practiced in the federal government, practiced at a big firm, practiced at a small firm. What I really think, though, was what I feel probably distinguished me from other candidates was my work in the community. I had served on numerous nonprofit boards over the course of my career, and part of what I talked about in the course of my interview was because of my experience working with so many different people, different communities, different socioeconomic classes, based on my volunteer work, that I was in a good position to work with and understand the people who come before the court, and to be an effective jurist in that respect, based on those experiences. And I think that it is those experiences that I had that might have pushed me over the edge.
So it sounds like if you're a young lawyer or a law student kind of listening and you are interested in perhaps getting to the bench one day, whether that's state or federal or appellate or trial, that in addition to having obviously a strong legal background, that community involvement and kind of a well-rounded set of experiences is something that may be beneficial to kind of getting them over that finish line.
I think so. And I think being purposeful about it, if you looked at my resume and my background, you might think that, this is somebody who set out to be on the bench because it looks like maybe I've checked all the boxes. But that I was just doing what I had passion for and what brought me enrichment. And so because of that, I feel like when I was in the interview talking about those things, I think that my passion for it and my heart for those things came through, which means my genuineness was showing through. And I think that was helpful as compared to, if I would not suggest to young lawyers, do these things just to check the boxes, because then I think your insincerity probably shows when you're, having your interviews as part of this process. So, be purposeful about it. Choose the things that actually you have passion for and that you find fulfillment with, and let that genuineness of you be reflected in your background of experiences, so that you can talk about it from a perspective of your truth of who you are.
I think you make a really good point about that. And that's something that, when I'm obviously still a young lawyer, but I do mentor younger lawyers and law students, and I'll often talk to them about how valuable authenticity really is. And it's really about finding who you are and then presenting that. Because, I think about my own practice. I never meet clients with a tie on. I'm just not a suit and tie kind of person. And of course, I'll put one on for court where it's expected. But I just don't come across. I don't speak like a person who wears a suit. I am joking and lighthearted. And, that's just not me. And so when I'm wearing one, I just don't feel as authentic. And people kind of pick up on that. They pick up on, especially kind of in trials and stuff, when you're talking to juries, they pick up on whether or not a person is being authentic to themselves. And so it sounds like, it's not necessarily about checking the boxes, but it's about, being true to yourself and really going where your passion and stuff is, because that will shine through.
Yeah.
You join a nonprofit that you're really passionate about, you're going to get a reputation as a passionate hard worker. You join a nonprofit that you really aren't interested in just to kind of check a box, and you're probably going to get a reputation as someone who's not always volunteering, who's not going the extra mile. And it may actually end up doing a disservice to you, even though it looks great on a resume.
Right. A disservice to you and a disservice maybe to the nonprofit that you're working with just for the sake of checking the box, because your insincerity is probably going to show through.
One thing I did want to ask you, if young lawyers are kind of interested in, your journey to kind of become a judge, or are looking for some advice in that realm, do you mind if they contact you?
No, by all means. I love making myself available to young lawyers. I also do that with law students. I like to be a connection for folks, to have conversations and ask the questions. When I applied for the job, I know judges generally, but actually I take that back. There were a couple of judges I did reach out to over the course of the process. But if you don't know people, if you don't know judges, you might be hesitant to put your hat in the ring for a position. And so I am more than happy to be a resource to people, so people should feel free to reach out to me. And
that's awesome. And it's something that I think I've stressed now on every single episode that we have, and I'm going to do it again, how important it is to find mentors, to find other people that have already gone down the path that you're trying to do for all kinds of different reasons, whether it's, advice about a specific legal thing, or you might want to mentor in your practice area. We had a prior guest talking about how important it is to find mentors for professionalism and ethics, and to really find a mentor that doesn't teach you just the what of practicing law, but how to practice law. And then obviously for networking and resources and things like that. And so that's really great. And I highly encourage our listeners to reach out to Judge Crews. I want to shift gears to kind of our main topic, and obviously listeners, you cannot see us, but we are sitting here in face masks. This is one of our first in-person episodes since the coronavirus pandemic. And so I guess my first question for you really is, how has COVID-19 impacted the federal bench?
Yeah, so it's had a pretty profound effect in terms of how we do our work. And its effect on our docket. So, for example, my clerks they've been working from home, I don't know, for the past 3 months now, maybe. So most of us are working from home. On the civil side of our docket, we're not really, granted, some of this is up to each particular judicial officer, but I think for the most part, most judges are doing things very similarly. so some of this perspective is really is a lot of what I'm doing, but no longer convening in-person hearings. They're being done telephonically with lawyers calling in. Usually we would convene a scheduling conference on the front end of the case, so the lawyers would come in, we'll talk about the schedule, discovery limitations, and so forth. But rather than do those on the phone, I'm just issuing scheduling orders in cases, and that's in part because my courtroom deputy, although my courtroom deputy is with me in the courtroom. She's running the FTR system, which records the proceedings so that there's a recorded record. She's working from home. She has 2 small kids. She manages it well, but I think it's easier for her. The less hearings I can have that she has to record, the better she can balance what she needs to balance. So, some efforts being made to not convene things and just issue certain orders, but otherwise doing things telephonically. On the criminal docket, everything that we do as magistrate judges is done by video conference. So the defendants are appearing by video, lawyers are appearing by video. We're being broadcast by video, but that's all being done by video. We're not convening grand juries right now, although I think we're starting this month, or maybe we just started this past week. But we're not convening grand juries. We're not holding civil trials or jury trials at least through July 6th. So there's been quite a bit of change for us at the court in terms of how we set about to do our business. Lawyers haven't stopped filing the motions, and so, those things are still there, and so we're still trying to get through all of that and issue rulings, but it's a little less efficient for us right now in the way that we have to do our work.
Are you guys doing, so I know you mentioned the video conferencing for criminal kind of issues. I know in state court we've gotten the option from some judges that if the parties are willing to waive the jury trial and basically doing an entire virtual trial to the bench, complete with witnesses and exhibits and things like that. Are you guys doing, in non-jury situations, are you guys doing any kind of full hearings or full trials at the federal level right now?
I don't know if anyone has done a full trial in that way yet. I know some judges have done, I know one of the district judges did a preliminary injunction hearing all by video. And other judges, I think, have held different hearings by video. So some of that is taking place.
It's a brave new world out there. I've been watching the Supreme Court even doing hearings by telephone.
Right.
And it's fascinating just to see, how society adapts. Because at some point, the show kind of has to go on a lot of the legal stuff.
Right.
And it's interesting to see what different jurisdictions and different groups are doing to kind of make that go forward.
Yeah.
Have you guys had discussions about, so I know in Denver, or not Denver, in the state courts, we are tentatively scheduled to resume jury trials after July 6th, although, of course, our Supreme Court could move that back, given public health concerns. Has the federal judiciary spoken about resuming kind of jury trials, and is that going to look substantially different kind of with social distancing? It's kind of hard to socially distance a jury. That's kind of the whole point, is to keep them together and keep them all in one room. Mm-hmm. Has there been discussions about kind of what that'll look like, and do you kind of have any insights on how we'll proceed?
Yeah, so our chief judge has issued a general order that has vacated all jury trials through July 6th. So probably within the next couple weeks, we'll have an all-judges meeting to discuss whether or not that'll be extended. Our chief is part of a COVID-19 task force that I'm not sure who all's on the task force, but it's judges across, federal judges across the U.S., and I'm sure medical professionals who are meeting and having discussions about COVID-19 and its effect on the courts. So I know that he's involved on an ongoing basis in discussions, which he then brings to us in all judges' meetings. And he and the district judges make decisions as to, what our court's going to do, whether our court's going to extend a general order, things like that. So there are discussions in that regard, and I imagine in the next couple weeks or so, if things are going to change, if that order is going to be extended or not, that a decision will be made.
Do you see, obviously, some cases have already been delayed. Do you see the federal judiciary has always been relatively backed up, especially if you don't consent to the magistrate, as you were talking about, just because, we just have a lot of cases and not enough judges. Do you see that delay in getting trial dates and stuff, getting substantially worse as a result of kind of the COVID situation?
I think it is likely inevitable that that's going to be the case. Trials have been vacated. I don't know what the numbers are on how many. But those are getting, I know I've seen some reset for later in the fall, whether they'll even go then, who knows. I think part of what we'll face is even if this general order is lifted and we can start doing jury trials, I don't know if those will actually resume right away, as people will still have concerns about social distancing. Jurors will have concerns about their safety. They may not want to show up for jury duty. And so I think those are all things that are likely under discussion, but things we'll have to sort through and figure out in terms of how quickly are we actually going to resume. And so the fact that things do get pushed off in that respect, inevitably there's going to be some form of backlog and further trying to dig out from that.
And I've been reading a lot of articles about COVID and kind of the jury system, and I think it's really going to be fascinating whether it has an impact on the diversity of juries, because, there are different groups of people that are more at risk of COVID. And, it's going to be hard to say if a person is, X amount of years old and they say, look, I don't feel comfortable, is that going to be excusable or not? And there's going to be a lot of really tough decisions that hopefully will be made by people a lot smarter than me on whether that's a fair jury and whether that kind of shifts the makeup of the jury. And it's going to be a lot of interesting issues, I think, kind of coming up that we're just kind of getting into exploring. And right. I think that the other thing that we were kind of talking about before the podcast began was really this, the fact that a lot of criminal trials have speedy trial deadlines. And so we may see a lot of judges, both at the state and federal level, kind of called in to do pretty much exclusively criminal in the near future to kind of clear that backlog. Have you guys had any discussions about kind of shifting everyone's focus to criminal kind of in the near term?
There haven't been any of those types of discussions. And for us, since as magistrate judges, we can't do felony cases. Those are for the district judges. So that'll really be for the district judges to determine how that's going to work out in terms of felony cases. Misdemeanor cases, those are ours, and we'll have to manage those for ourselves since those are on our docket.
I'm assuming, I guess I don't know because I don't practice a ton in federal court for criminal, that the overwhelming amount of crimes on the federal level are felonies. Are there a lot of, federal misdemeanors, if you will?
There are federal misdemeanors. The ones I've seen so far are things like people getting unruly on airplanes, and they're being charged with something based on that. But things that drinking on federal land or something, or speeding through the Air Force Academy, those would be misdemeanor crimes that are things that come before us.
I wanted to touch on one other current event that is kind of addressing the nation or sweeping the nation right now. We're shooting this at the very first week of June, and here in Denver and across the country, we've been witnessing large-scale protests against police brutality and violence, all spurred by the unfortunate death of George Floyd in Minneapolis at the hands of law enforcement. I know that your situation as a judge kind of limits your ability to comment on this, but I wanted to ask you as obviously a black male, but also as a judicial officer, as someone with children who is kind of, eventually going to have, discuss these kind of issues, what you kind of view as the legal community's responsibility or some of the things that they can maybe do to try to address these situations.
Sure. So, I'm still a new judge, a relatively new judge, coming up on 2 years. But one thing I have had to learn in all of this is the balance and the lines. Where are the lines for judicial officers in terms of how we as judicial officers can or can't be involved when things like this happen, to the extent that a judge wants to assist in some way. So I am learning that as all of this is happening. What I would say to young lawyers is, one thing I've said to young lawyers before, a message I like to convey is, when I became a lawyer, I learned that there was a privilege that came with having a law degree. When I became a lawyer, nonprofit organizations began to seek me out to serve on their boards or to volunteer my time with their organizations. And I felt that was because of my law degree and this presumption of power and competence and so forth that comes with that. So there's a measure of privilege that comes with having that law degree. And I think that for those who are in pain and who are hurting and who want to make a difference, lawyers are in a better position than others to know where and how and what levers to pull to make some tangible change around issues that affect our community. And so I would just encourage young lawyers to find those levers, recognize the privilege you have as an attorney, and exercise that privilege, and maybe seek out nonprofit organizations that are doing things around the type of change that you want to see. And really volunteer and give of your time and put that effort in, leveraging your power as a lawyer to really get involved and effectuate change.
To echo kind of what you say, I always think back to that famous quote from SpiderMan, that with great power comes great responsibility. And, I've had some of these discussions with my colleagues about pretty much what you just said, that I was like, when it comes to like public health issues, people look to doctors. Mm-hmm. They look to doctors as credible thought leaders on those issues. And when it comes to issues of law and policy, especially in the criminal justice system, they look to lawyers to kind of lead as a thought leader and to contribute to that discussion and to add an air of credibility to kind of what you're advocating for.
Right.
And it's a tough time for our city and a tough time for the nation. But there's been a lot of hope and a lot of peace kind of over the last few days, both here in Denver and other places. And sometimes it gets drowned out by the negative people that are out there. But a lot of people, I think, have been working really hard on these issues and continually, or hopefully will continue to do so. So I usually end these interviews by asking, do you have a good email address for our listeners if they do want to contact you, or what's the best way to kind of contact you if they're a law student or a young lawyer that, to set up coffee or just to kind of pick your brain?
Sure. I'll give my chamber's email address. And so I'll say it and then I'll spell it, but it's crews_chambers@cod.uscourts.gov. So CREWS _ the word chambers, CHAMBERS @cod.uscourts.gov.
Well, thank you so much, Judge Crews, for coming on the program. It was very enlightening, and thank you so much for the work that you've done in the community and coming and speaking with us today.
All right, thank you.
Get legal with it.